And we're live. All right, welcome everybody. Thanks for coming to the office hours for Intro to IP Part 1. Hello from sunny and beautiful Philadelphia, Pennsylvania, where it's about 5 o'clock in the afternoon on a Monday. And welcome to all of you from wherever you are. So I think the way that I'm going to do this is I'm going to go over the questions first that you guys presented beforehand. Hannah compiled those. If you want to follow along, you can look at the discussion board that has all of those questions listed, and we'll go through them. As I go, if you have a follow-up or want me to elaborate on any of them, then go ahead and type in your questions, and they'll show up here on my screen, and I can get to those when I can. So without further ado, we'll go ahead and plow ahead. So question 1 is from Venkatamurti. I hope I got that right. And the question is, lots of jobs are being outsourced, so how does the IP law work in this situation? Do they use international IP law, or do they consider both U.S. and particular countries' IP law if the situation arises? And then an example here was nuclear reactors in India are tied up or have arrangements with the United States. So as a general matter, intellectual property law is territorial, by which we mean each country has its own version of intellectual property law. Patents, copyrights, and trademarks are generally applicable only in the countries in which they are granted. So for example, a US patent is only enforceable inside the US. A Chinese patent is only enforceable in China. Same with copyrights and trademarks and so forth. So if you have an international conglomerate or an international company, for example, then very often what they will do is get patents in a variety of places. Not necessarily every country in the world, but a lot of them. And primarily related to which markets they plan to operate in will dictate where they go and get, for example, patents. And so it's likely, in the case of the nuclear reactors, I don't know for sure, but it's likely that companies in the U.S. that have created inventions related to nuclear reactors have filed for patents in India or even elsewhere probably to protect those inventions in those countries as well. And so that's how it works. So although patents are very territorial, it's very common for a multinational corporation to file for the same invention, file a patent for the same invention across a whole bunch of different marketplaces. So question 2 is from Paula. And Paula says, I want to be enlightened about the nature of exceptions to the rules that took place after March 2013 regarding the prior art. So March 2013 was the shift over that we've talked about throughout the course from the pre-American Invents Act to the post-American Invents Act. The most important change, and the one that Paul is referring to here, is related to what we mean by prior art. And what she means by that and what I mean by that is that we changed in the United States in March 2013 from a first to invent system to a first to file system. That changed what we think of as prior art. In a first to invent system, things that are prior art are those things which are previous to your invention. So if I'm an inventor, the prior art would be those things that were published or otherwise publicly known prior to the date that I invented my invention. After the AIA went into effect in March 2013, that changed. And now the prior art is everything that comes before I file for my patent application. There are, of course, some exceptions to that. We learned about that in the course. But in general, that's the biggest change. The idea is that we've broadened the scope of prior art by moving it from everything that was prior to your invention to everything that was prior to your filing date. And that has meant that it can be harder, and I think it probably is harder for smaller companies to get patents than it was before. So question 3 is also from Paula. The concept of Goldilocks solutions. And so the idea of the Goldilocks solution is comes from the fairy tale where Goldilocks was heavily involved. And what it means is basically is that what we're looking for in intellectual property law is sort of that happy middle ground, that area where the law is strong enough to create the benefits that we want, but not strong enough so as to cut off either new innovations or raise the costs of having the law so high that we diminish the overall benefits. So a Goldilocks solution is sort of like when Goldilocks was feeding the porridge to the three bears, and what the three bears wanted was just right? They wanted it not too hot, not too cold, just about right. And that's what we want essentially in patent law. We want laws that are strong enough and secure enough in helping inventors protect their inventions, and yet not too strong so that they retard or hurt future innovation or raise the costs of enforcement and so forth. So question 4 is from Rosanna F., and she asks, what does memorialize mean? So memorialize is a fancy way that lawyers say to record it, to write it down. And so when we memorialize a transaction, for example, or a patent document, what means we're writing it down, creating a written record. Question 5, Jenny DLR. It was nice to hear your initial lecture, and I appreciate your clarity. I did have one question. Can you give an example of IP other than aspirin, which has lost its distinction? So I think what you're referring to, Jenny, is trademark law. And of course, trademark law is the subject of an entire other course, which part 2, which is going to start April 5th. And I strongly recommend that all of you take that course as well. And what you're also talking about is the idea that trademarks can essentially lose their value or lose their distinctiveness because they become appropriated by the public for a particular idea. So aspirin is one example. Another example of that is trampoline. So trampoline used to be a trademark, and now, of course, it just refers to the generic product that kids bounce on, or adults. Dry ice is another example. That was originally a trademark of a chemical company, and they essentially lost the trademark because people started just referring to the product as dry ice. All right, question 6. This is from Midori 365. One way to overcome hindsight bias is to limit your ability to combine prior art. Who is the you? Is it the inventor or the examiner? For 103 rejections, examiners can combine different prior art references and make combined references a reason for rejection. To combine prior art sounds like jargon for IP people. Well, yes, as I'm sure everyone has realized by now, patent law has lots and lots of jargon, as all areas of law do. And so I would urge you to ask questions whenever you run across concepts, ideas, or words that you don't, or phrases that you don't understand. And so what we mean by combined prior art, of course, is the idea that under Section 103 in the non-obviousness analysis, what you can do is take individual pieces of prior art and you can combine them together to cover all of the elements of the invention and therefore prevent the patent from being valid or from issuing. And so the you that I'm talking about, when I say you, to limit your ability to combine prior art, can refer to basically two different types of people. The first, of course, is the examiner. And the examiner in the U.S. Patent and Trademark Office is the one who is evaluating every patent that comes in the door for whether it meets the standards of validity. And the other the other person that could be doing this would be, for example, a judge or a jury who is evaluating whether a patent is valid after it's already been issued and if it's in litigation. So one of the things that's interesting, I think, about patent law is that once you get a patent past the patent office, you are granted an issued U.S. patent, you still have to enforce it. And you enforce that through the federal courts in the United States. And that process, part of that process will be that whoever you enforce the patent against is likely to try and defend his or herself by saying that your patent is invalid for failure to meet the various standards of the patent law, one of them, of course, being non-obviousness. And so that means that this validity analysis that is done initially by the patent examiner is also later done by courts, by juries, and indeed it's evaluated by lots of people when they're trying to determine whether they should, for example, get a license to your patent, or whether they need to avoid your patent, whether they're going to be restricted, and what kinds of products they can create. So all of that is important in thinking about how people use patents. And so the you of who can combine prior art is really everybody, because it's everybody who wants to evaluate the obviousness or non-obviousness of the patent. Question 7, Venkata Murray. So this was a question about a Delaware tech meetup, and they had a website. I don't know anything about the company that you mentioned there, Venka, so I'm not sure I can offer any advice as to whether or not this would be a useful thing for students or not, but if people want to go check that website out and that company out, I think that would be fine. All right, question 8, DMCB. Can a court correct inventorship if the omitted co-inventor had no deceptive intent, as explained in week 5? What if the co-inventors had deceptive intent? What remedies would be available? So under the case law, as you remember from week 5, an omitted joint inventor, if you are omitted from a patent, you can be added as long as you, being the omitted co-inventor, don't have deceptive intent on your part. The law actually doesn't say anything about the co-inventors who left you off. So for example, if your co-inventors have deceptive intent in leaving you off of the patent, as far as the law of inventorship correction is concerned, it doesn't matter. You can still be, as the joint inventor, you can still be added. However, the problem there is that because your co-inventors, because your joint inventors committed what is known as inequitable conduct, which is a defense to patent infringement, inequitable conduct, which is bad behavior before the patent office, basically lying to the patent office about various aspects of your patent. Here, if you intentionally leave a joint inventor off of the patent, you're clearly lying to the patent office. So therefore, your patent would be unenforceable under the law, which is essentially the same as having your patent invalid. So an unenforceable patent can't be used. It's not technically invalid. You just can't use it to enforce against anybody else. All right, question 9 from Maria Clara. So question 4, the week 4 quiz. And then the question here is that you refer to asks, in determining whether a claim on an invention is obvious, information pertaining to the commercial success of the invention or the long-felt unresolved need for such an invention may blank. And the answer here, the correct answer here is may be submitted by the inventor. It's optional. A inventor does not have to submit what is known as either secondary considerations or objective evidence of non-obviousness. However, you may submit it at any time. You may submit it either to the examiner, or you may submit it to a court that's evaluating the non-obviousness of your invention. Either one. So that's the answer to that one. Many patents, of course, or many patent applications won't have secondary consideration type evidence. It's the case that you may not have commercial success at the time that you're applying for a patent. It may be that you may have commercial success, but you can't show that it was directly related to your invention. Lots of reasons that you might not have these secondary considerations. So it is not required, but it can be quite helpful to your case of non-obviousness if you can find it. All right, question 10. All right, Paula Tangainho. I understood the lesson about statutory bars. I'm confused about the meaning. Could you please give me a sentiment? So a statutory bar is a limitation on the ability to obtain a patent that is almost always based on a patentee or a patent applicant's own behavior. This, of course, is what occurs pre-AIA, meaning this is in our first to invent system. Under the first to invent system, prior art is only those things which are disclosed prior to your invention of your product, of your invention. A statutory bar, however, is something that can pertain to you as the inventor. So for example, if you sell your invention more than 1 year prior to filing it, filing for the patent, you have triggered a statutory bar. Even though technically what you haven't done is disclose your invention prior to your invention of it. So it wouldn't technically be prior art, but it is a statutory bar. So it's just two different ways to think about the novelty requirement. One is prior art, which are, in the case of the pre-AIA law, those things which come before the date of invention. And the other is the statutory bars, which are those things that occur more than 1 year prior to the filing date, even if the invention date is well before that. So it's two slightly different ways of thinking about what prior art is. Note that statutory bars are often thought of as being triggered against the patentee or the patent applicant, him or herself, but third-party activity can create statutory bars as well. So if somebody else, for example, sells an invention, even if they don't even know what the invention is, if they're selling it on the public market more than a year prior to your patent application, that can trigger a statutory bar as well. All right, question 11, Davis. So you want a question about the Alice case, more details about the impacts of Alice on recent patent activity and claim strategy, something that seems to come up frequently among your colleagues when discussing patents in general. Do I have different perspective towards moving towards a more European approach, i.e. don't patent them? I have a professional interest in knowing that changing dynamic could impact whether it's worth patenting certain types of inventions, whether it goes below 100%, and so forth. So this is a great question and really interesting. So what you hear from people who do a lot of patent prosecution and a lot of patent litigation is that the Alice case has fairly dramatically changed patent law, particularly with respect to software patents. As you will know from the materials on Alice, the Alice case really changes the equation in terms of what an abstract idea is and makes it a much broader, much more nebulous concept. In my view, makes it much less certain. That uncertainty, I think, has resulted in courts and the patent office both being quite aggressive about limiting how software patents work. And so there are the incidence of software patents being declared invalid has risen dramatically in the post-Alice era. And at the patent office, it has become much, much more difficult to get a software patent granted through the office. So you ask what this means, and I think the answer is we don't really know yet. This is an ongoing area. The courts are still working out exactly what the parameters of Alice mean. I think it's definitely the case that it is going to be harder going forward to determine what is and what is not patentable, particularly in the software and high-tech area. That said, I'm not sure that the U.S. has gone all the way down the road of not having software patents at all. And part of that is because what we're seeing right now in this sort of surge of patents being declared invalid is a lot of patents that were written and prosecuted and understood under the prior pre-Alice law. And so because the prior law was more lenient with respect to software patents, they were easier to get, then there wasn't as much attention paid to exactly what we mean by an abstract idea and tying the software somehow into the technology. And so when you talk to people who are prosecuting patents right now, they believe that they can still get patents on software, patents on a lot of high-tech applications and devices, but you need to claim these inventions in a slightly different way than you did before. You have to really tie them into a particular real-world application. You have to make them seem technological, almost physical in nature rather than intangible in nature. And the thinking is if you can do that, you should be able to pass the Alice requirement, and that should, over the long run, allow for lots of patenting in these areas. So I guess my thought is that we in the US are not going towards Europe. which does allow a lot of software patents in very much a similar fashion. So although they typically don't allow patents on software per se, you can get patents on methods, and you can get patents on technologically implemented methods, and all of those things are just versions of software. My own personal view is that I think it would be a terrible idea to try and ban, for example, software patents. Because anyone who has any experience in software and hardware and computer technology knows that software is just the same as hardware. It's just not actually burned on a chip. It's just not actually a physical manifestation. And because that difference between the physical and non-physical is easily manipulated and really doesn't make any sense from a technological perspective, then it also doesn't make any sense to try and ban one type of manifestation of technology in favor of another. And I think that we'd be better off by focusing on things like, is the patent truly new? Is the invention truly innovative? Is it non-obvious? Does it disclose enough? Those are the types of questions I think we should really ask, rather than fighting over whether or not it fits into a category of software, hardware, or something like that. All right, next question, question 12 from MEJ25. If a person has an idea for an internet business, but is not a coder, doesn't have a website or a business, can the idea be patented in a preliminary patent? And what should the person do to protect the idea before and after the business or website starts? Can confidentiality agreements be enforced against IT developers without consideration, parentheses, money? So under the law, you of course don't need to have an actual manifestation or actually physical product. You don't have to have a working prototype in order to get an invention, as long as you can fully disclose, or in order to get a patent, sorry, as long as you can fully disclose what it is your invention does. So you have to meet the enablement requirement, you have to pass all the prior art tests, you have to be able to write it up and so forth. None of those things actually requires you to have a prototype or a website or anything like that in place before you file for the patent application. And indeed, in this era, you are probably well advised, if you have an invention, to go ahead and file for a patent application earlier than you might otherwise. I think that having an early filing date is always a good thing, especially in the post-AIA first to file context. Now, there is still a grace period. So if you published a website that had your idea on it, for example, you would have a year before that publication itself was used against you, but you are probably generally better off to file for a patent application earlier rather than later. As far as your question about confidentiality requirements, that's well outside of the scope of this course. My only answer to that would be to note that lots of times the consideration for confidentiality requirements is not in the terms of money, but just in the terms of the information disclosed. And so sometimes you don't need to exchange money in order to have a valid confidentiality agreement. But as with all of these things, if you have questions about details like confidentiality agreements or whether you should file a patent, how to file a patent, you should consult an attorney and not me. All right. Your second question was, are the IP laws adequate for the internet businesses? Or are they lagging, and does Congress need to improve them? So my own view on this is that the patent laws we have are perfectly adequate for the internet era, for the technological era, and so forth. I think you do see an uncomfortable fit sometimes between things like software and internet technologies and the patent system. I think we're going to see a lot more discomfort when we get into trademark and copyright in part 2 of the course. But the patent law has, over the last several decades, shown itself to be remarkably flexible and remarkably resilient to technological changes. And I think that is to the credit of the law, that it generally allows anything to be patented as long as you meet the basic criteria. Now, I am concerned, and this goes back to a question that I talked about earlier with respect to the Alice case. I am concerned about the recent efforts from the Supreme Court to take areas of technology, such as software or high technology, and sort of wall them out of the patent system. So I think that's a bad idea for a variety of reasons, in part because of the question here, which is one of the benefits of the patent system is that it has proven to be so flexible. And as technology changes, the patent system has adapted reasonably well. There are certainly reasons to be concerned about aspects of the patent system. As you know from my course, the claim construction area, I think, is a real mess. And I think there are lots of areas of the patent law and individual cases or doctrines that could be changed to make it better. But I think if you step back and look at it from a larger view, in general, we've done a pretty good job in the U.S. of striking this balance between protecting as much as we can, allowing a lot of flexibility for new inventors to enter into the market and create inventions that can be patented and then protected by the patent system, while at the same time not spending a lot of time fighting about categorization and which things fit into which box. And so I hope that continues. I hope we don't go down the road of having different kinds of patent law for different kinds of technologies, although some people have suggested that would be the better way. I just don't think that would work. All right, question 13, Paula Tangenho has a question about exercise 3 from the 4th week. And the question there was, can a patentee trigger a statutory bar on himself? And the answer there is yes. Of course, the patentee can trigger a statutory bar on himself. This goes back to an earlier answer where I explained the difference between traditional understandings of novelty and statutory bars. Question 14. DMCB had a recent case in the Hedwig-Lismont case that they used terms such as latches, barred by latches, the power of latches, and presumption of latches, and equitable estoppel. So latches is a legal term that basically refers to the fact that if you do things or wait too long, you as a rights holder, you can eliminate or reduce your rights. So if I have a claim against you for example, a traffic accident or something like that, there is a set period of time that I have to before my claim expires. And the idea here is that we don't want sort of claims against people to go on forever. I can also trigger latches by saying things like, oh, it's okay, I'm not going to sue, or go ahead, you can use my invention. Those types of things can often create latches too. Latches is a particular principle in the law, an equitable principle, and principles of equity mean that those are things that judges decide on matters of fairness. So a judge deciding an issue of latches will consider whether it seems fair to limit the patentee's ability to pursue his or her claim and decide accordingly. Because it's a matter of equity, it's really hard to draw any long-term principles about it. But in general, the idea is if you do things, say things, or wait too long before you enforce your patent, you can essentially lose the right to enforce your patent. All right, question 15, Michelle Omedo. So you want to ask your opinion on the Patent Cooperation Treaty, or the PCT, and the Unitary Patent and the European Patent Convention. Do these supranational treaties forget the territorialities behind the patent system, or are they adapting to the reality of globalization? It's clear they boost patent filing, but they as well be slowing down innovation by creating patent monopolies, and since now even less countries that consider only national novelty having to switch to worldwide novelty, making it possible for big corporations to cope with international registration costs. This is a great question. So one of the things that's going on, of course, as Michelle suggests, is a series of treaties that have been enacted over the last several decades. The Patent Cooperation Treaty is one example. The Unitary Patent, the European Patent, is another. These treaties generally, you are correct in that they seem to be undermining or changing the territorial nature of patents. And I think that that's an important fact. And what's going on here is sort of a balance. On the one hand, we think that territoriality of intellectual property rights is likely to be a good thing because they allow individual countries to slightly, at least, adapt the intellectual property laws for their own situation. So, for example, certain countries might want strong patent laws because they have a very well-developed innovation industry. Other countries might have a relatively less developed innovation industry and a better manufacturing industry. So they might want lower intellectual property laws, less strong intellectual property laws, so as to allow more manufacturing without interference from intellectual property laws. And territoriality allows the different countries of the world to basically adjust their patent laws to meet their own circumstances. On the other hand, we all live in a worldwide market where, as I noted earlier, innovations that start, for example, in the US can spread all over the world. Innovations that start in Switzerland, for example, can spread all over the world. And because of that, these large multinationals need some ability to understand what it means to invent something, and that having different sort of rules for patentability, for inventiveness, for enforcement all over the world adds huge amounts of uncertainty, and with uncertainty comes cost, and with cost comes reluctance to enter into all these markets. So all the countries of the world also have an incentive to harmonize their patent systems as well, to try and make them similar to each other so that businesses can understand what it means to have a patent in Canada, for example, what it means to have a trademark in Mexico. All of these things have real value in terms of boosting your local economy. And so like everything else with intellectual property law, it's a balance. On the one hand, countries want to be able to adjust. On the other hand, they want to be able to coordinate and harmonize. And that's what these treaties are all about. These treaties are sort of the first steps that countries are taking towards harmonizing, integrating their patent systems. So the Patent Cooperation Treaty, for example, is a treaty that allows you to file in one place, and if you pay the appropriate fees and elect the appropriate circumstances, you can then seek patents throughout the world in a number of other jurisdictions, all from one common patent application, thereby saving you some money and saving you, in some cases, a lot of time. That is thought to be a good thing because it diminishes uncertainty. It can diminish costs for companies that want to be able to patent worldwide, and it can increase the amount of innovation altogether because it makes patents basically more valuable everywhere that they are. So I don't think they're necessarily doing away with territoriality, although it is definitely going that direction. I think from the perspective, one of the interesting things about international patent law is that from the perspective of large, very well-developed countries like the United States, we would, of course, in the US, like for all countries to have a very strong patent system just like ours, because we, of course, have a comparative advantage. We have lots of research institutions, lots of high-tech companies, and so forth. It is not necessarily clear that every country in the world would benefit from the same system as the US. As I noted before, countries that had a strong manufacturing base, but maybe not as much in terms of the innovation base, would probably benefit from weaker patent protection. And so one of the issues in international law or international intellectual property laws is how much can the US and other highly developed countries require less developed countries to have strong intellectual property protection as a condition of, for example, being part of the WTO and other things. And so that's the subject of a lot of negotiation. The U.S. Trade Representative, which is the primary person in charge in the United States government of seeking and enforcing trade deals, spends an enormous amount of time in intellectual property rights because one of the comparative advantages of the United States is our intellectual property creations, both patent and innovative and inventions, as well as film, movies, books that are covered by copyright, as well as multinational brands that are covered by trademarks. So all of those things are very valuable to the United States. And so we spend a lot of time as the U.S. In lobbying other countries to harmonize their laws with the U.S. Question 16 from Maria Clara. Does the PTO have to consider information pertaining to commercial success or long felt and unresolved need? And yes, the answer is yes. If the patentee has that information and submits it, then the PTO has to consider it as part of the non-obviousness requirement. That's the same, by the way, if it was in litigation and the non-obviousness was being litigated. Question 17 from Ibuzia. What do I think of a well-known trademark dispute? Well, trademark is part 2 of the course, so I'm going to hold that question until part 2 starts in April. That sounds interesting, and I'll keep that question aside, and we will answer that in part 2. I hope you'll join us then. Question 18, 3141 pi. So I wonder if the US approach to patenting abstracts concept is shared by the rest of the world. And two, isn't it possible that courts are in over their heads without any strong foundation in the areas of abstract concepts, and their native intuitions are harmful as well as embarrassing? So I think that you are exactly right that the courts have struggled a great deal in terms of figuring out what an abstract idea is, and therefore what is not patentable under the law. And I do think I share my own personal views that Alice is sort of an embarrassing case because it does pretty much reveal that the courts don't fully understand what they mean by abstract idea. And I think that that is generally harmful. As far as what the rest of the world does, the rest of the world is basically very similar to the United States on this. They may have slightly similar ideas about what can and can't be patented. Sometimes they describe it in different ways. There has to be a technology or a technological innovation. They mean something akin to what Alice does. Nobody has figured this out. Nobody has figured out what the difference is between an abstract idea and a non-abstract idea. And so therefore, I'm not confident the courts are going to get this right anytime soon. Again, my view is that we should generally evaluate patents solely on the basis of whether they meet the other standards for patentability, such as 112, 102, and 103. I think those are perfectly adequate for measuring whether a particular invention meets the standards for patentability. And I think that most of the issues that you see in subject matter, Section 101, are really just Section 112, 102, or 103 issues that for a variety of reasons the courts have decided to decide under Section 101. So question 19 from AJ Ohm. I have a broad question that's philosophical and practical. So in medicine, it happens that useful molecules are found against a disease by exploring nature. An example is an antibody that neutralizes HIV found in the blood of an HIV-positive individual, but free of any symptoms of the disease due to the antibody. One can argue that the composition is not patentable since it was made by an unconscious trial and error, but the molecule was only discovered by an individual analyzing the blood. However, there's a lot of effort in discovering the antibody, characterizing it, and mass producing it in order to make it into a useful drug, all of which from a utilitarian point of view is desirable to incentivize. Can you discuss or muse on the big picture with respect to patent law and discoveries and things in nature where a human inventor in a strict sense cannot be defined? So this is a great question. It goes to this distinction that the courts have made since the early 1980s between discovery, which is not patentable, and invention, which is patentable. And I think the idea here is that invention brings something entirely new to the world, whereas discoveries are merely illuminating things that are already there. And arguably what the courts are trying to do is change the incentives and make people search for things that are entirely new as opposed to search for things that are already there. I think you're 100% right, however, that from a utilitarian perspective, you can often look at things like, an isolated version of an antibody and say that is truly valuable. That could be, in fact, life-saving and life-changing. And from a utilitarian perspective, would dramatically raise our quality of life and therefore should probably be patentable. On the other hand, looking at the bigger picture, I think you can argue that what we want to do is instead encourage people to make new things, to make entirely new forms of antibodies, to make synthetic versions. And this is indeed where the Myriad case sort of cuts the line. And what that case says is that isolated and purified of naturally occurring products are not enough to be patentable. It has to be something more than isolated and purified. It has to be purely synthetic. So in that case, the synthetic versions of the DNA strings were patentable, whereas the non-synthetic versions that were isolated and purified are not patentable. And that distinction, I think, gets at this idea that what we want to do is primarily encourage invention, the creation of entirely new knowledge, rather than encourage mere discovery. But I think you're totally right to say that even discoveries can be very valuable. but we may think that discoveries are likely to occur anyway, that people have plenty of incentives to make new discoveries, and what they may not have enough incentives to do is to create entirely new information, to create entirely new things. And so that could be why we in the patent system encourage, or in fact require people to create inventions rather than discoveries. But that's a great question. So question 21 from Norlita. If there's a patent submission from Korea and USA at the same time with a similar product, where should the litigation of the patent be? And so again, this goes back to the fact that patents are territorial. And so the litigation, if there was a dispute over that patent, would be wherever the patent holder wanted to bring the dispute. So typically litigation can occur at wherever a large market is. So if the primary market for the product, for example, is in Korea, then I would expect that the litigation would go forward in Korea. Similarly, if the primary market was in the United States, then I would expect that to be in the United States. So again, the territorial nature of the patents are going to allow a patentee to basically choose the forum in which he or she wants to litigate. So question 22 from Deborah Freeman from lecture 1, why can't the benefits of increased IP activity be quantified? If only in terms of GDP for all the products, etc., or do you mean in terms of quality of life? So you can definitely quantify economic growth and success. So I didn't mean to imply that you couldn't. You can certainly measure a whole bunch of things that you could relate to innovative activity. You can even count, for example, numbers of patents. You could count the numbers of new products released, those sorts of things. The issue is that it's really hard to determine what the contribution to that growth is from intellectual property laws and what the contribution to that growth is from things that are not the intellectual property laws, right? So we know from innovation that innovation sort of grows on itself. Everybody, in a sense, stands on the shoulders of giants. You learn from the person who came before you. And so some of that might have to do with intellectual property laws, right? It could be that that original innovation that you're building on was developed because of IP, or it could be that it was developed completely accidentally, has nothing to do with intellectual property laws. Or it could be that once you saw the first iPhone, you had this idea for a new app. It doesn't have anything to do with your ability to protect that app or get a patent on that app. It has more to do with your sense of the technological development, right? And so the issue with measuring the value of IP or measuring the impact of IP isn't so much that we know whether or not things are getting better. We absolutely know that the last 10 years have been a huge boom in software, handheld devices, apps. All of those things have been on a huge boom in terms of their growth rate, how much they are used, how many, the benefits that they offer to society and so forth. What we don't know is how much, if any, role that intellectual property rights actually played in that boom. I think it played at least some. But we also know that it can't possibly have played the entire role, and that that patent rights in particular operate on the margins. And what I mean by that is they are designed not to have somebody who would otherwise never create anything at all to encourage them to go ahead and become an inventor. That's not how they work. They just aren't strong enough to do that. What they can do, however, is shift your incentives slightly. So somebody who is going to invent, they might make you invent something that was bigger, something that was stronger, something that was more impactful to society. Why? Because the laws are going to protect you only if you can get over the hurdle of non-obviousness, for example. And so that, I think, is what the patent laws can do, is not necessarily create sort of entirely new groups of inventors, but affect their incentives on the margin and push them towards making slightly bigger inventions, spending a little more money, a little more time, reaching a little further along the innovation pathway than they would otherwise. So let's go to question 23. This is Alejandro. Biopiracy and patenting of indigenous knowledge. Is there any functioning mechanism for the communities to prevent their patenting of their wisdoms? So the idea here, I think, if you were thinking about ways to protect indigenous technology or local technology, the best way to do this in the modern environment is to publish, and publish as much as you know as your country knows about what's going on there. Because, of course, once you publish, then your innovations cannot be patented in other countries. And some countries do this. Some countries have fairly systematic efforts to try and compile indigenous communities' knowledge. Some countries don't. And I think if they don't, and if this goes sort of unrecorded anywhere, if it's not published or otherwise known to the public, then it is at risk of being patented by people who do find it, people from developed countries who do find it out. But that's a great question. So question 24 from Yvonne, can you review the effects of the equivalence doctrine on patent scope? That reaction is it would narrow the scope, not expand it. No, it expands the scope. So the doctrine of equivalence is the doctrine that says you can get equivalence to the scope of your patent claim. And the way that this works is you first get your patent claim construed. And so you'll remember from claim construction that you do that by trying to figure out under Phillips what the meaning of each patent term is. And there you get a scope of your patent grant. When you go to enforce it, you can not only get that scope, but you can get a little bit beyond that. And how much beyond that is what we call the equivalence of that patent claim. So when you think of a patent's total scope, you can think of that area covered, the subject matter covered by the patent claim, plus the equivalence of that patent claim. Now, as you'll remember, there are lots of limitations and exclusions to the doctrine of equivalence. So it's not always the case that you get equivalence of your patent. But in general, the law says you should be able to get equivalence. So question 25, Murdy asks, what's the first patent act legislated by Congress? What are the requirements for patentability? And what is the first patent granted? So the Patent Act of 1790 was the very first patent act. This was one of the first areas of legislation in the United States. The standards were relatively similar to those that we know today, with a couple of exceptions. The requirement that you have patent claims came in later. Initially, you were required to provide models or other examples of your invention. And the other thing that was an important change is in the 1850s, we developed the obviousness requirement. So the standard got a little higher for getting a patent. Pre-1850s, you merely had to be novel. The first patent was granted to Samuel Hopkins for an improvement for making potash, which was used as a fertilizer. And that was patent number 1 in the US, and we're up well over several million at this point. Second question, when was non-obviousness introduced as a requirement? This was in the 1850s, as we went over in that part of the course. This was an innovation by the courts. It had sort of filtered up through the courts and finally enacted into law by the Supreme Court in the Hotchkiss case. Since when have the product patents for pharmaceuticals become mandatory in the USA? So the US has always granted patents for chemical compounds, which fairly neatly apply to pharmaceutical products because they are generally chemical compounds. So question 26 from Anonymous. Do publications include journal articles, conference presentations, company flyers, press releases informing customers, etc.? And I think the answer to that is generally yes. So anything that's reasonably publicly available counts as a prior publication. So what reasonably publicly available means is that it's possible for people of skill in that field to find the information if they wanted to. So it usually means that it was published, but it can often mean it was talked about at a conference as long as people knew how to follow up for it. There have been cases that have said that if you have a PhD dissertation, for example, as long as it's indexed by subject matter at any library in the world, that can count as publicly available. And the idea then is that it has to be reasonably publicly available. It doesn't mean it has to be easy to get. It just means it has to be publicly available. So what does disclosure mean? Does it mean the act of letting the world know about the new discovery invention? The answer here is that disclosure means making it publicly available. So what we talk about when we talk about disclosure is making it publicly available, allowing others beyond the inventor and his or her close personal family to understand and to know the patent. Third question from Anonymous is, how much information does one need to divulge to be considered as a disclosure? should it include most of the claims and descriptions? So no, it does not have to include all of the claims and descriptions. All that a prior disclosure needs to include is enough to put a person of skill in the art on notice about the invention. So it doesn't have to be fully enabling like a patent application would. It has to be reasonably enabling. It has to provide enough information that a person of skill in the art would know that there is an invention there, but maybe not all of the little details that would be required later. So question 27. Could you please give additional examples of strategic uses of claim scope description and how too broadly or too narrowly defined descriptions worked or didn't work? So I guess the answer to this is almost every case that we cover in this course has to do with strategic behavior on the part of the patentee and claim scope. Everything that we do in terms of looking at patent cases that have either succeeded or failed and so forth has to do almost entirely with choices and strategic choices made by the patentee. So I guess there's not any one particular example I can give you, as much as I can say almost every case that we do in this course has a lot to do with how claim scope either gets too broad or too narrow and therefore either invalidates the patent or fails to cover the intended products. All right, question 28. So this is also from Deborah Freeman. So I'm confused about the infringement example of the wooden pencil. So if a patent is valid for A, B, and C, it does not protect the inventor from a later infringing invention using only A and B. You're correct about that, right? So leaving out the eraser component, which is what your question is about, allows people to make a version of the pencil without infringing. And so the context of your question suggests that that doesn't seem right. And I think the answer to that is, if I make a pencil that doesn't have an eraser, and what you have patented as a pencil with an eraser, I've essentially created a different product, right? You declared in your patent that an eraser was a required component of your invention, and I left it out. So I've created a different product. So I think that's how this works, is that we think that what you put down as your claims of your invention are what are required to be in your invention for infringement, and therefore that's the scope that you get, and you don't get any further than that. And yes, I can avoid your patent by leaving out elements, but of course, when I leave out elements, I'm making a different kind of invention. What that does show you, though, is that a patentee should be very careful not to include any elements in his or her claim that are not required in order to make the invention work. So don't put an eraser in your invention, in your claims of your new patent, unless that eraser component is actually a required piece of your invention. If the invention that you're conceiving of would require an eraser. If it doesn't require an eraser, don't put the eraser in there. And so that's sort of the way that the patent law is intended to work, and in fact does work. So let's go to question 29. From Alejandro. Perhaps it's a wrong impression, but being the patent systems are national and national borders, the situations which national and international undertakings, the court decisions seem to favor the home player. Is there any hope for an international patent system, and is there any attempt of harmonization? So I think that this is basically covered by what we talked about earlier with respect to the efforts that are going on right now towards increasing harmonization. Do I ever think we're going to get to a world patent? No, I don't think so. I think at least not, in any time in the foreseeable future. I think that there's just too much incentive on the part of different countries to have slightly different systems. And countries like to be able to at least adjust their systems to some extent. I think what you're going to see is a continuing effort on the part of the well-developed countries to expand the scope of patent rights worldwide, and on the part of the less developed countries to resist that and to narrow the scope of patent rights. And I think this will just sort of keep going back and forth for quite some time. I don't see a dramatic change in that anytime soon. What I do think you're going to see a lot more of is cooperation and agreement between the patent offices of a lot of different countries' patent systems. And I think this has the possibility of being very, very beneficial. Patent examination is hard work, and it takes a lot of resources, takes a lot of effort. And I think that not doing that work over and over again, if you are applying for a patent in multiple jurisdictions, is very beneficial. And so I think the more that patent offices can share the prior art searches that they make, or the construction of the claims that they create, those sorts of things that take time, take effort in one place, if you can transfer that knowledge to a different patent system and speed up the process, make the process cheaper, better, more efficient in another area, then you're going to overall increase efficiency and make things better for everybody. And I think that's mainly where you're going to see development in the future, and that's already started. There are a number of agreements between patent offices that should go that direction in the next 5 to 10 years. All right, we have another question from Demra. When is it practical for a very small inventor to seek the assistance of a patent attorney in applying for a patent or during patent prosecution? So I think, like many answers in law, it entirely depends. In my experience, patents that are written with the assistance of a patent attorney are much more likely to be found valid and to have value in the marketplace than patents that are written by individuals. Now, that said, individuals can file their own patents, but my experience is they're probably not very good at doing that. And I guess I would recommend that in all but sort of the most extreme circumstances that you try to at least, a small inventor tries to at least consult with a patent attorney about the invention that they want to protect. How are patent attorneys graded or evaluated? So to my knowledge, there's no systematic grading or evaluation. Patent attorneys, in order to call themselves a patent attorney, have to pass a special bar exam for at the patent office called the patent bar. And that qualifies them to practice before the patent office. It basically shows that they know the policies and procedures of the patent office and so forth. And so that's a qualification standard. That's not a rating system. It doesn't tell you how good they are. It just tells you they've passed a certain bar. Beyond that, there really isn't a systematic effort to grade and qualify patent attorneys. All right, question 31 from Big Eyes. Discovery versus invention. So is discovery versus invention what causes the medical research community to stay away from natural elements, that is herbs and plant matter, versus using synthetics? So it is certainly the case that, and we talked about this earlier, that the law very much favors invention over discovery. And so if one of your goals is to maximize your ability to protect things, then you're going to want to invent rather than discover. And I think that the rest of this we sort of talked about earlier, that the reasons why and so forth. That said, I think you do see plenty of big pharmaceutical companies involved in seeking information about even naturally occurring products. And I think that's for a couple reasons. One is they might be trying to figure out the mechanism, which itself may be patentable if it's not naturally occurring. And the other is, patents aren't the only way to protect yourself in the marketplace. You can keep things secret. You can create contractual relationships with suppliers. You can have other distribution mechanisms. So it might be that the plan in a lot of these areas is to increase your ability, increase the protection that comes from non-patent mechanisms as well. So question 32. Has the time come when we argued there should be a global patent process? So we've had this question a few times. I think you can certainly make the case that we live in a global economy and that we are innovating globally. I do think that at least at present time, the countries involved have a very different states of their innovation economy. The US is highly developed in that regard. Europe is very highly developed. Several other countries are highly developed. I think that because there's so many differences right now between countries, the idea of a global one-size-fits-all patent, although it sounds somewhat attractive, is probably not something that we're going to see anytime soon. But it's a great question. And then final question, Aurelia asks about the protection of traditional knowledge. There's no specific rule about protecting traditional knowledge? No. So there's no specific rule about the protection of traditional knowledge. However, if knowledge is truly known in the sense that it's publicly understood, publicly available, then it's unpatentable. So in that sense, traditional knowledge is essentially off limits for patenting, or at least should be if people know it. If people don't know it, then there's the potential for people to patent it once they find out. Although I think as time goes on and technology gets better, communications get better, people communicate a lot more, the amount of traditional knowledge that is truly not known in the public world becomes smaller and smaller, and there's less of these issues around. All right, we are almost done with office hours. I see there's one question on the list that I'm going to answer from, I can't pronounce the name, but I will try and answer this one. So are there any more objective assessment methods other than those presented in the lectures of non-obviousness? For example, quantitative evaluation, etc. So no, there really aren't, at least none that the case law has allowed. Those are the ones that the courts have credited as being objective evidence. I'm not even sure what quantitative evidence of non-obviousness would be, other than something like the amount of innovation, which would be a great thing to measure, although I think it's really hard to measure. So there you go. If you come up with a quantitative measurement of the quantity of innovation of a particular invention, that would certainly be something that you could maybe patent itself and get a patent on it and suggest it as a potential secondary consideration. All right. So I believe that we have reached 6 o'clock. I'm being given the thumbs up over here saying that we are done. Thank everybody for coming and watching and joining us in this. I hope you're all enjoying the course. This course ends next week, and then part 2 starts up April 5th, and I hope to see you all there. We'll do this again in class 2. If you have further questions, comments, suggestions, and so forth, please let us know on the discussion boards. Both myself and Hannah and Kai are on the boards a fair amount, watching what's going on, and really enjoy hearing both your questions and your comments and suggestions about the future of the course. So have a good day, and thanks for attending.